This conference will now be recorded.
So I'd like to welcome everybody who's joining me today on March 19th, 2021 for the 7 signs you need an estate planning checkup. And today we're going to talk about what those events are and what you should be looking out for. So there's that famous line out of a song, sign, sign, everywhere a sign, and sometimes the signs are there, but we tend not to pay attention to them because we don't know what they signify. We don't understand their importance. So some of the major life changes that can happen in a person's life that should then lead to an estate planning checkup would include if you're getting married or remarried. The reason for that is if you have existing documents, we might need to update and include your new spouse. Or if you have a marriage or a relationship that's ending in divorce or separation, again, that's a good reason to reevaluate the plan that you previously put into place. Also, if there are new births in your family, you might want to include those people as potential beneficiaries. And certainly if somebody has passed away, we want to know that as well because we might need to revise your estate plan. Another thing we want to look for in signs is when there's a change in the law. Now that could mean that there's a change on the state level where you live, or it could mean there are changes in federal law that are going to apply everywhere in the country. So that's another important sign to watch out for. Another sign we want to be mindful of is if you have an existing plan and a person you've named as your fiduciary has died or is now incapacitated and may not be able to take on the responsibilities you've asked them to, it's a good time to have an estate planning checkup. Certainly, if you have a change in financial circumstance, always a good time to reevaluate. And that coupled with changes in the law, we're going to talk about in a little while, you're going to see we might have to do some tax planning. And then the last sign we're going to talk about today is why it's so important to coordinate the formal estate plan with what we call the informal estate plan. So we're going to start today talking about people who are newly married or remarried. So most people don't know that in Florida and in many states around the country, a spouse is automatically entitled by law to a certain percentage of their spouse's assets when the spouse dies. Here in Florida, we call that the elective share. And in Florida, it is 30% of whatever the deceased spouse owned. So that means it includes assets the spouses owned together, assets the decedent had in their own name, assets that the decedent owned with somebody other than the spouse, and believe it or not, it also includes assets that the deceased spouse named somebody else as a beneficiary on. So we have to always talk about this when there's a marriage or a remarriage, because if the intention is not to share any of the assets at death, then it's important that both spouses understand they need to have a prenuptial agreement or a postnuptial agreement that says we are not going to make any claims in each other's estate when we die. We're not going to pursue any rights we have to inherit under Florida law. People who don't know that and they miss that sign then pass away, and lo and behold, we have a surviving spouse making a claim. And in fact, I have a situation like that right now where one of my clients' parent recently passed away, and her will acknowledged that she was married, identified her husband, and then it said, you know, we are aware that my husband has a right to inherit, but we don't plan for him to do that. Now, unfortunately, they didn't sign a prenuptial or a postnuptial agreement waiving rights. So there's a very good likelihood that the surviving husband is going to file a claim in her estate, and he will, by law, be entitled to receive 30% of the assets. Another thing to look at when we marry or remarry is our incapacity plan. So the incapacity plan are the documents that allow us to name someone we trust to make medical and financial decisions when we are incapacitated or disabled. So those are documents such as our durable power of attorney, our designation of healthcare surrogate. Well, if our documents name a spouse or a partner or significant other we were previously involved with, but that relationship has now ended and now we're in a new relationship, it's important to update those documents and cancel the prior documents, because we don't want anybody getting confused about which document should they follow, which document is legal. So also look for that sign as well. It's important to update the estate plan as much as it is important to update the incapacity plan. Now, if you have young children, minors under the age of 18, that's a third type of legal plan you don't want to forget to update. So remember that natural parents, the mom and dad, whether they conceived the child or they adopted the child, they are considered natural guardian until age 18. However, you can designate in writing a guardian for your minor child should you and your spouse become incapacitated or both of you pass away. So you might want to update the guardian designation in the event the person you named as the guardian unexpectedly becomes incapacitated or they pass away. If your plan for your children includes leaving their inheritance in a trust till a certain age, you might also want to reevaluate who you designated as the trustee to oversee the inheritance. You want to make sure that person is still healthy, that they're still willing to take on the responsibility. So this is a three-part sign that when we see it, we want to pay attention and not ignore it. Now, equally important is the sign of what needs to change when somebody becomes widowed or divorced. So interestingly, here in Florida, we have a law that says once the order of divorce is entered by the court, even if you don't change your will, your divorced spouse is considered to have predeceased you. So in a sense, they're automatically removed from your last will and testament. But that by itself doesn't necessarily give you a new plan. So don't rest and think everything's okay because I've got this final judgment of dissolution of marriage. You really want to reevaluate and write a new will. Now, this law only affects a will. It does not affect a document such as a revocable trust. So please be very careful, because if you do get divorced and you name your ex-spouse in the trust, they're not necessarily going to be disinherited. If instead you are widowed, your spouse has passed away before you, most likely you have named that spouse as your primary fiduciary, your primary medical decision maker, your primary financial decision maker. your personal representative, perhaps your trustee. Well, it's always important to have enough alternates named so that you have that backup plan. It's what I call the what if plan. So if plan A doesn't work out the way you thought it was going to be, you have a plan B. Well, when you're widowed, it's important to see, okay, who do I now have named as my alternate fiduciaries? If I only had my spouse and one alternate, now the alternate becomes the primary. I don't have an alternate named. So it's a good idea to revisit the conversation and make new decisions. Florida also has a law that says when two people become legally divorced, their power of attorney and their designation of healthcare surrogate documents are automatically treated as if the ex-spouse predeceased. So again, it sounds like, hey, that's a good thing. It happens automatically. But I don't want you to rest on your laurels and think there's nothing else you need to do or should do. It's really important, unless you have a great, positive, continuing relationship with your ex-spouse, to then go ahead and make sure you have enough alternate fiduciaries named to cover you. If not, we want to cancel, we want to revoke those documents, and we want to create new ones. Similarly, if you become widowed and your spouse was named primary fiduciary, you want to update the power of attorney and the healthcare surrogate. And if you have a plan or need a plan for your children following your divorce, you can choose to name a guardian over assets that you might leave to your minor child. And by naming a guardian, you choose the person. So if you don't want the child's parent, other parent, to look over assets should you die first, this is the way that you maintain control over that decision. You can also now, under Florida law, name in writing a healthcare surrogate for a child under 18. So let's say you have primary custody of the child and you're going on a trip abroad. You can name a surrogate to make medical decisions in your absence. Now, another sign we certainly don't want to ignore is when there's a new birth. That's a great reason to update your plan. It might be a new niece or nephew, a new grandchild, and you might say, hey, I really want to include this new member of our family as a beneficiary. So it's a great time to revisit what your estate plan says. Now, some people tend to think in terms of leaving a specific dollar amount. I'm going to suggest that it's better to work with a percentage rather than a dollar amount. And the reason is that in Florida, our law says that if there's an insufficient amount of assets to pay specific sums to beneficiaries, then there's nothing left to distribute to the people you want to receive what is left, what we call the remainder. So let's do an example. Let's say you named 5 grandchildren and you said, I want to give $25,000 to each of those grandchildren. So that would be approximately $125,000 of specific gifts. And then your will says, I leave the rest of what I own to my 2 children equally. Well, if it turns out that on your last day on earth, you have less than $125,000, then only the grandchildren are going to inherit. And by accident, the 2 children will have been disinherited, which for many clients is really not what they ever intended, but it happened by mistake. So that's why I say, let's work with percentages. If you assign everybody a percentage and you get to decide how small or how large the percentage will be, that is a way of assuring that each of your beneficiaries is going to receive something. Nobody will be left out unintentionally. So if you're thinking about now switching to percentages, sit down with a pad and a pen and start thinking about the amount of the percentage for each person, and then make sure that when you add up your percentages, they total 100%, not less than and not greater than 100%. In designating a new beneficiary who's joined the family, you want to consider the age. If this person is under age 18, they're not yet a legal adult, the law says that child cannot hold the assets for themselves. Somebody else needs to do that. So there are two choices. Choice one is we write a trust for the minor age beneficiary. You get to decide who the trustee is, who's going to be in charge, and you get to decide at what age or ages the monies are going to be distributed to the beneficiaries. What a lot of people like about having a trust for a minor beneficiary is they feel that they're still exercising some amount of control, with the hope that as the beneficiary becomes an adult, gains life experience, they're going to gain wisdom and hopefully responsibility, so that when they actually receive the inherited assets, they're going to spend them wisely and not foolishly. So a trust allows people to exercise control. The other option for a minor age beneficiary is called a custodianship, and the other name for this is the Uniform Gift to Minors Act. The acronym is UGMA, UGTMA. So custodianship account is where we write in your legal document that you want this to be held until the child is 18. And you name the person that is the custodian who will oversee the account. When you pass away, the person named as the custodian will receive the inheritance. They will go to the bank, open an account in the name of the custodianship, and deposit the money. When the child reaches age 18, the child can go to the bank, present their birth certificate, and request that the bank deliver the assets to them. By law, the bank cannot continue to hold the assets past the person's 18th birthday. So these are two very different options. One gives you more control, where you can extend holding on to the assets until a later age, whereas the custodianship only allows the assets to be held until age 18. Now, if there's a new birth, let's say it's your own child, you do want to think about naming a guardian. And this is not always a pleasant thought. It's certainly not a pleasant conversation to have with your spouse. Nobody wants to think that we're going to be unable to raise our children, or that, God forbid, we will pass when our children are still under 18, but it's been known to happen. So it is a very good idea to name a preemie guardian in writing, and you don't necessarily have to choose the same person to be guardian of the assets as the person you want to be guardian over the person, meaning who the child will live with, who will give medical consent, and who will decide what school your child attends. What's important is that this be done properly in writing, and then the document is filed with the court. And the reason for that is so that if you do have an accident or an illness and you're incapacitated, and now we need that guardian to actually be appointed, then the clerk is able to retrieve the document for the judge when we file for a guardianship of your child. It's not a good idea to include this language in your last will and testament. It's a very archaic way of doing it, and if you're still alive, there's no reason for us to file your will. So if you want your will to maintain confidentiality, it's really best just to designate in a separate document by itself. And remember, a couple of minutes ago, I did mention that if you have a minor age child, it's a good idea to designate a healthcare surrogate for the newborn. So we look at the designation of healthcare surrogate for a minor as a tool. It's a way to actually be able to stay out of court, not have to do a guardianship for a minor for medical decision making. And that to me is really the ideal. If we can keep people out of court, we can keep their lives private, we can limit expense that would be incurred, that's really the way to do things. It gives you the ability to decide who that surrogate is going to be, select an alternate surrogate, and to have the peace of mind of knowing that if you're incapacitated or you pass away, you're temporarily unavailable, any of those things occur, you've got a surrogate who can step in, and their authority is going to be recognized by the doctor treating your child or by the school. Now let's talk about changes in the law, because changes do happen. We just can never know in advance how often changes in the law are going to occur. For example, in 2011, the Florida legislature made major changes to our durable power of attorney law. So prior to the change, we could write a power of attorney for a client, and it could be springing, which meant that the client didn't want the document to be effective right away because the client was still healthy, still in control of their affairs. So we could include language saying this is not effective until the client is examined by their physician, and the physician signs an affidavit saying that the patient is no longer able to handle their financial affairs. Well, in May of 2011, we lost that ability, so we can no longer write any springing durable powers of attorney. And what that means is now when this document is written, it is effective immediately. So if you really don't want the person you've named to start acting for you and making financial decisions, you don't want to give them the original document, and you also don't want to give them a photocopy. And that's because the new law says a photocopy is as good as the original. But it is important for you to tell the people you've named as your fiduciaries where they can find the document should you be in an accident, should you be unconscious. They need to know where to find it, otherwise their hands are tied and the document doesn't do what we need it to do. Now keep in mind that the power of attorney is not giving this trusted person ownership of your assets. It's only giving them permission to take care of the assets and to pay your obligations. So the nice thing about that, and what I think is the safer thing about having a durable power of attorney compared to adding somebody's name as a joint owner to your account, is you're not subjecting your assets to any unforeseen liabilities of your fiduciary because they don't own it. Unfortunately, that's not the outcome if you decide to add another person's name on as a joint owner, thinking that you're making it easier should you become incapacitated. Because what will happen is if the joint owner gets a divorce, files for divorce, they have to report your bank account that they're listed on in the divorce proceeding. And in Florida, we divide assets based on a standard called equitable distribution, which is pretty much down the middle, 50-50. So it will not matter to the judge that your fiduciary didn't put any of their own money into your account. The judge still has to consider dividing that account. The same result could unfortunately occur if your fiduciary has to file bankruptcy, either because they've incurred personal debt or because they had a business that didn't do well and they're filing bankruptcy for the business. You also don't want to jeopardize your assets if, God forbid, your fiduciary has an accident, is found to be at fault, and gets sued by the person that was injured. So these are all good practical reasons to select the durable power of attorney rather than adding somebody's name on as a joint owner. Now, when this change in the law occurred, which became effective October 1st, 2011, it gave us a really great gift. And the gift was that when we write the document, we have to spell out about 10 superpowers. Now, we call them superpowers simply because they are high levels of financial decisions that might need to be made for you. So you get to choose whether or not you're giving your financial decision maker the ability to exercise the superpowers. For example, one superpower decision is, do you want your fiduciary to create a trust for you if it's beneficial, but you're incapacitated? Do you want your fiduciary to make gifts of your assets? Maybe you've had a pattern of making gifts on birthdays or certain holidays, or perhaps you have done tithing to your church or synagogue, or maybe you're a big proponent of making charitable donations. Well, if you are, and you want that to continue, you need to give permission to your fiduciary to do gifting. So when you come to sign your new durable power of attorney, you're going to initial next to each superpower saying either yes, I'm giving permission, or no, I'm not giving permission. So this is a really important conversation for you to have with your attorney if you're first having a durable power of attorney written, or if you're having an estate plan checkup and you're going to update or revise your existing durable power of attorney. Now, back in the year 2020, Congress passed a new law. It's referred to as the Secure Act, and it covered a lot of changes, but the one we're going to talk about today affects people who have an individual retirement account, what we call an IRA. And so this is a new change in the law that might affect your estate plan and might be a good reason to have a checkup. So the law used to be that when we reached age 70 and a half, we had to start taking distributions from our IRA. And if you waited to a later age, you actually were penalized and you had to pay a tax. They've now raised that age to 72. If you turn age 72 in 2020 or later, you must start taking your required minimum distributions. Now, either your accountant can calculate that for you, or the bank where you might have your IRA can calculate that for you. The other thing that changed with the Secure Act is there's no longer an age restriction on being able to continue to make contributions to your IRA, which is great, especially because not only are people living longer, but many people choose to continue working past age 65. So this is very helpful for them to continue to grow their retirement assets. What did not change with the Secure Act is that if you're married and you designate your spouse as beneficiary of your IRA, your spouse can roll over the inherited IRA into an IRA that they may have in their own name. So that's still an available planning option. But what has changed in the law is how non-spouse beneficiaries inherit the IRA. So the new rule is that a non-spouse inheriting an IRA must receive all of the IRA monies within 10 years of the date of death of the owner. The only exceptions to that, where it can actually be stretched out over the beneficiary's lifetime, and the benefit of being stretched out is you are stretching out the period of time of paying income tax on that money. The only people that are accepted are a surviving spouse, a minor age child, somebody under 18, a beneficiary who's disabled or is chronically ill, and so that has to be documented in writing by a physician, or an individual that is not more than 10 years younger than the decedent who owned the IRA. So because this is a new change and it does affect tax planning, it might be a reason for you to have an estate planning checkup, as well as a checkup with your financial advisor and your accountant. So now that we have a new president in office, we might be thinking, what else is in store? What is Congress planning? Well, there is discussion of possibly changing what we call the estate tax exemption. This exemption allows every person, regardless of marital status, to either gift during their lifetime or give away at their death assets up to a certain amount without having to pay a gift tax or pay estate taxes to the federal government. Currently, that exemption is $11.7 million per person. So when you're married as a couple, that sum is doubled. So there is discussion about reducing the estate tax exemption to almost 1/3 of that, approximately $3.5 million. Congress is also discussing whether to reduce the gift tax exemption down to $1 million, and they may be considering increasing the tax rate, how these assets are going to be taxed for people over sums, raising it to 45% on the calculation. So Congress is looking at these issues. We're probably going to know more in the next couple of months. So do read the newspaper or listen to the news so that you know whether you need to do some estate tax planning. Now, another sign we want to look out for and certainly not ignore is if a person we've named as a fiduciary in our plan dies or becomes incapacitated. So we've talked about the importance of having a backup plan. So if your primary fiduciary dies, it's a good time to look at your documents and see how many people do I now have left as alternates. And if the fiduciary becomes incapacitated or has been diagnosed with an illness, you're not sure if they're going to be able to take on the responsibility, we really should revisit the plan. You might want to change the order of people. You might want to name new people and take out that fiduciary who's now ill or incapacitated. So I suggest that you start by dusting off your documents and then sit down, have a cup of coffee or a cup of tea with your trusted family members or trusted friends. Ask them if they're willing to take on either being the medical decision maker, the financial decision maker, the personal representative, or the trustee. Many people I find in my law practice have a tendency to just immediately say, I'm going to name the eldest child, because they think that that's the way things should be done. But the eldest child may not necessarily be the right person for the job. So I like to suggest that you match what the job entails with the person who either has that life experience or that job experience or has the qualities that are needed. So you wouldn't want to name the eldest child to make medical decisions if they get too upset and nervous. You need somebody who's going to stay calm, somebody who's going to be very collected in their thought process. Also keep in mind that naming somebody as an agent is not limited by where they live. So if you're in Florida and you're thinking of naming somebody as a fiduciary who's in California, it doesn't necessarily mean it's a bad idea. You want to first have the conversation with them, make sure they're willing to do this, and that they understand if they're going to make financial decisions, they're going to have to get on the phone. They might have to sign something and email it back or fax it back. If they're going to be the medical decision maker, again, they have to be available by phone. They might have to sign a medical informed consent form, and they might need to get on a plane and come here to make medical decisions. If you don't have children or you don't have people that you feel you trust, you might then want to consider selecting a corporate fiduciary to make financial decisions. That could mean a bank or a trust company. And probably the change we all want to happen is the change in financial circumstance. So if you are the lucky winner of the lottery on Saturday night, you have three things that you really need to address. The first is to reevaluate your tax planning. The second is to reevaluate your retirement plan. And the third is to reevaluate your long-term care plan, because now you may very well be able to fund and pay for any long-term care that you need. Or if you're young enough and you now have the money to buy a long-term care insurance policy, that might be a great thing to explore, knowing that you're never going to be without the necessary health coverage that you need. Now, one of the mistakes people make, and it's not an intentional mistake, it's an unintentional mistake, is they don't coordinate their formal legal plan with their informal estate plan. So this is a reason to get qualified legal advice and not try to do it yourself. And here's the scenario that I'm talking about. You can name beneficiaries on a lot of different assets. You can put a beneficiary on an account at the bank. You can name a beneficiary on a life insurance policy. You can name a beneficiary on an annuity or stocks. When you do that, the result is that when you pass away, that person will present the death certificate to the financial institution and they will receive that asset. But if your last will and testament or your trust agreement says that three other people are intended to inherit, they're not going to receive that asset at all, because the will and the trust don't control the outcome of assets that you designate beneficiaries on. So you could end up creating an unintended consequence. So it's really important that when you sit down with a qualified attorney, that you first check, do I have beneficiary designations on any assets? And if I do, who are the beneficiaries and what assets are they listed on. Then you're in a better position to make an informed decision. Do you want to leave it that way, or do you want to take their name off so that the will or the trust will control the outcome? Or you might want to add other beneficiaries' names on. So there's a lot of different options here, but what's important is that we look at things with eyes open, not with eyes half open. There can also be a problem unintentionally created if you designate a beneficiary on an asset and that person happens to be receiving financially sensitive government benefits. An example would be somebody who receives Medicaid assistance or food stamps, or perhaps they receive a monthly check from Social Security called SSI. Unfortunately, when you designate that person directly as a beneficiary, they now have assets that are countable, and it's going to cause them to lose their benefits from the government. The better way to structure it is to create a special needs trust for them, either in your will or in your revocable trust. And by having the money go directly into the special needs trust, they won't lose the government benefits. So they'll get the best of both worlds. They'll be able to have the government benefits pay for basics, and then the money that's inherited in the special needs trust can be used to supplement and hopefully provide them with better quality of life and better quality of care. Another problem that can be unintentionally created is if you list a minor as a beneficiary on an asset and you die and they're still under age 18. I had said a little while ago, a child is not allowed to hold assets in their own name. So that would mean we would have to go to court, spend time and money to do a guardianship for that child. Whereas if you tell the attorney, I want to leave something to this person and they're not yet an adult, the attorney could write a trust and the trust will receive the money, and then everything is taken care of privately out of court and we don't need the guardianship. So in conclusion, I want to encourage everybody to start by dusting off their documents, talking with your family and friends so that you can select and update who your decision makers are. If you're looking at updating your beneficiaries, you want to think about, does this beneficiary need a trust? Does this beneficiary have a disability? Do they have an addiction? Are they just not responsible yet and they need to grow a little bit older? So we might have to figure out what type of trust is going to be best for them. Remember to use percentages rather than dollar amounts. And if you can't think of a trusted person, you might want to think of a corporate fiduciary to be a trustee. Don't forget to talk to your children or grandchildren as they're approaching their 18th birthday, because they are becoming legal adults and they should have some simple legal documents as part of their plan before they go off to college or enlist in the military. So I want to leave you with some tips to help you on how to choose and hire an elder law attorney. And hopefully these tips will help you no matter where you live in the United States. You are certainly able to interview the attorney and ask them about what their practice area is. If somebody only dabbles in estate planning, probably not a good idea to hire them. You want to find out how many years have they been representing clients and doing estate planning. And if your matter is more involved in the area of elder law, then you want to ask them what percentage of their practice is devoted specifically to elder law issues. Certainly ask them if they're board certified in the area of estate planning or elder law. That means they've continued to enhance their skills and their knowledge. They had to sit and pass an examination. Ask if there's a consult fee. Will that consult fee be applied toward the services? Will you give me your proposal in writing so I know what you're going to do and what it's going to cost me? You can also ask for a reference or see if the attorney's website has client reviews listed on it. You can go to the State Bar website just to make sure that they are still able to practice, that they're still licensed. You can look to see if there's been any disciplinary matters for that attorney. And the NALA.org website is a great resource if you need to help somebody in another area of the United States and you don't know where to start. Go to NALA.org. You can do a search for an attorney starting with the state, and then you can narrow down your search to a specific city or town in that state. And most of all, you want to have a good, positive customer service experience. You want to be comfortable. You want to feel that what you're sharing is being kept confidential and that the communication is clear. So I want to thank everybody who joined me today and remind you that we host these webinars twice a month. So if you're not on my email list, please let me know. I'd like to include you. Otherwise, you can go to the website, to our calendar page, and you will see there all the upcoming webinars, and you can register for them. If you did register, but last minute something happened and you couldn't watch the webinar live, we do record them, and so you can go to the webinar recording page a couple of days later and watch it at your own convenience. And don't forget that on the website we have a gift certificate for 20% off on the initial consultation. So at this time, I'd like to open it up to any questions. Well, since there are no questions, thank you for joining me today. Have a wonderful weekend. Stay healthy and stay safe.